Hello, everyone. Firstly, thank you very much for having me at this excellent conference. My name is Ruya Toparlak, and today I will be talking about a combined approach to transparency in artificial intelligence, how law could support and benefit from explainable decision making. So this is the overview of my presentation today. First, I want to talk about transparency as a term and the definition and the purpose and ethical goals it serves. Then I will move on to the GDPR and the right to explainable decision making. And here I want to talk about both the general transparency obligations and the specific transparency obligation and the information to be provided in case of qualifying automated decision making. And then I want to illustrate a relevant example from recent case law to better understand how this obligation is interpreted. And then I want to move on to the challenges of transparency that go beyond what information is to be provided to identify the combined approach needed. And I will mention examples of different explanation approaches that are to be taken into account while choosing the appropriate AI tool. Lastly, if I have time, I want to briefly mention the transparency requirements in the new Draft AI Act. So transparency, to set the scene. In many cases, transparency as a term can be quite opaque because different fields have different expectations of the same term. So generically speaking, transparency means being seen through a quality of openness and no secrecy. Whereas in legal understanding, it means an insight to the judicial, administrative, and legislative processes, and it is a part of right to information. Whereas in computer sciences and AI, it means the ability to explain and communicate elements relevant to an AI system, including the data, the algorithm, and the outcomes. It should involve making explicit how the particular set of factors which determine the outcome affected the conclusion reached. So to better understand how this come together in the regulatory setting, we can see the goals transparency serves, which is enhancing trust in AI, enabling the use of rights and safeguards in the accountability mechanism, and enabling judicial review of that decision. So these, to a certain extent, do point us towards the explanations and explainability of that automated decision-making, because from the point of view of the affected individuals, explanations do inform the data subjects on why a decision was reached, they enable the use of rights and safeguards, and they help the individual to understand what could be changed to receive a positive decision in the future. So when we look at GDPR now, as you know, Article 5 regulates the general transparency principle and the information to be provided in Articles 12 through 15. So this is, as you know, applicable to all personal data processing, but in addition to these, if the automated decision-making is considered qualified ADM under Article 22, there is an additional requirement. But for this additional requirement to take effect, the decision-making needs to pass the threshold of Article 22. And this happens when the decision is based solely on automated decision-making and it produces legal or similarly significant effects. So if the decision-making passes this threshold, the additional requirement is that you must inform the data subject of the existence of the ADM and give meaningful information about the logic involved, as well as the significance and the envisaged consequences of such processing for that data subject. So this is said to require only a clarification, basically, of the categories of data used to create a profile, the source of data, and why that data was considered relevant. And the goal of this in terms of transparency is providing ex-ante information of the fact that controllers are engaging in ADM. And it doesn't necessitate to give out information about the safeguards against ADM or information that would be particularly useful to exercise the data subject's rights. So in short, this is as far as the legally binding nature of explanations go under the GDPR. But in practice, some enforcers are applying these rules to cover additional information than the mere existence of profiling or the automated decision-making. And these more broader interpretation would include categories of personal data processed for it, such as details about how the profiles were created and the practical consequences for their creation. And in addition to this, some law enforcers are also starting to push for recognition of right to obtain meaningful information about the logic involved in automated decision making in all cases of automated decision making and profiling, and not just the ones that pass the threshold of Article 22. So the problem with this specific requirement in case of qualifying ADM of having the right to meaningful information about logic involved, significance, and envisaged consequences is that it is way too general and way too limited at the same time. It is general because it is not specified which and how information meets this requirement, and it is limited in its application because of the threshold of decision that only produce legal or similarly significant facts, plus it needs to be based solely on ADM, as I said. So here, formulating more particular procedural rights to interpret these transparency requirements and providing particularly useful information to trigger the safeguards listed in Article 22, paragraph 3, would be ideal. But without this, calling for transparency in the sense of more information is not that helpful and muddles the waters even further. So now I want to mention relevant example from recent case law that illustrates what this obligation holds better. And this is about a woman in Austria who was denied the extension of her mobile phone contract that would have resulted in the payment of 10 euros per month. Here, the decision to deny was based on a credit assessment carried out in an automated manner. And the case is currently in front of Vienna Regional Administrative Court now. And in February of this year, the court asked for a preliminary ruling from the Court of Justice EU. And the question they raised is, what is meaningful information about the logic involved in the significance and consequences of credit scoring in this particular instance? And more precisely, does this enable the woman to understand the automated decision-making in the individual case, including the disclosure of the individual's process data, parts of the algorithm on which the profiling is based, relevant information on the profiling process in the form of a list of the most important factors considered, and lastly, can the controller invoke legitimate business interest to avoid disclosing this information? So in light of these extensive questions, we see that there still is a need to better understand how data protection rules apply to automated decision-making and novel technologies like AI and machine learning so that new legislative efforts like the AI Act do not add further confusion. But I should mention that so far in the case law for transparency requirements for qualifying ADM, mathematical explanations, access to algorithms, and detailed information about the computing systems have not been required so far. However, according to the Vienna courts, this information here in this instance would include input data used for profiling, parameters and variables used in the profiling process, the mathematical formula used to compute the rating, enumeration and explanation of each profile category, and an explanation of why the individual was assigned to a particular profile, as well as other profiles in a pseudonym to verify the individual ADM's accuracy. So quite extensive, as you can see. And let's say that business interest does not apply and all of this information, the mathematical formula, the algorithm, and a huge corpus of data is provided. So then the question becomes, how is the woman whose phone plan application was denied going to use this information and check this information? And even the courts, do they have the capacity to process and make sense of this extensive information? So this brings us to challenges that go beyond what information is to be provided and how. So for the challenges of transparency, first point, which type of information is to be provided and how, I already talked about that. Second, we come to balancing of rights, legitimate business interest, and trade secrets and AI secrecy. And here I should mention that Even though an algorithm is protected under trade secrets, explaining decisions based on that algorithm does not need to necessarily encroach upon this secret. It depends on the scope of the explanation as well as who's checking it. And then we come to the correct amount of information to be provided to the stakeholder in question to cultivate trust. Because this is a challenge, because explanations that are too vague and too specific both create feelings of distrust. And here the complexity of the stakeholder and their expectation of transparency for that particular tool need to be taken into account. Next, we come to a big one, and this is the competency of enforcers, judges, courts, public authorities tasked with making sense of this information. So this is important because GDPR assumes safeguards and rights to access to information to be interpreted and exercised through courts and public authorities. And in many cases, courts are inadequate to process information they are already provided with. And in these instances, calling for transparency in the sense of more information or technical explanations for black box decision making isn't necessarily useful to combat this challenge. And the point here is that developing and strengthening the court's understanding and administrative agencies' capacities to process complex AI-based decisions must become a part of every AI transparency initiative and political initiative as well. And I want to give an example here. So UNESCO recently held a MOOC for judges and legal professionals called AI and the Rule of Law. And it had 8 to 9 different courses from predictive policing to credit scoring to pricing algorithms. So almost all instances where judges would be faced with this application. And at the end of these courses, it held 2 open Q&A sessions for judges and professionals that attended. So initiatives like these are very important to combat these challenges and increase transparency, because if we do not have institutional mechanisms set to deal with the information provided and ensure transparency, we risk putting the burden on individuals to make sense of the information, like these huge data corpuses. And this can create further cynicism and distrust if there is no system ready and capable of using the information to create change for that affected individual. And lastly, we come to another point that I want to mention, and this is transparency and trust in the socio-technical environment where that automated decision-making is deployed in. So we should contextualize the use of these tools in a broader sense. And the question to ask here would be that how are transparency practices embedded into wider organizational and cultural context of the socio-technical systems these ADMs are a part of? Because if we see transparency as a link to trust for the AI, like many guides in the AI package of the EU suggest, while availability of information and the technical research in explainable AI is important, cultivating trust needs a broader approach, because trust is placed on the person who deploys these tools, to the doctor who uses AI tools help in diagnosing the patient. It is placed on the police force who deploys these predictive policing tools. So it goes beyond the information transparency. And to cultivate trust, we should strengthen the general transparency practices in these systems. So to summarize up until this point, while individual information rights are important, they are one component and should be accompanied by regulations addressing other challenges of transparency. Explanations are to be understood in a larger structure. Second, we come to computer science. So explanations do not have a single computer science definition or approach, and therefore it is hard to legally define what and which approach would meet the meaningful information about the logic involved requirement for different cases. And if we look at explicability closer, technical research in explainable AI is important because it tries to provide a post hoc interpretability of a decision. In general, here, different explanation models are being discussed for different types of AI to allow affected individuals to better react to the decision by challenging the decision or changing their own behavior. So if we enhance here the courts and judges' understanding of these explanations approaches and the specific procedure that was used in the AI in point of contention, it might also help them to interpret the information requirements of the GDPR better. And this is just a table for these types of explanations, some of them that are being discussed. So this point can also affect the AI model chosen for the job. Because, for example, for the use of AI in low-risk decisions that carry almost no moral weight, explanations might be put on the back burner for the sake of accuracy if there's a trade-off there. But this, of course, needs to be evaluated on case-by-case basis. So lastly, we come to the transparency requirements in the new draft AI Act and how they add to the already existing regime. And I'm going to very briefly mention this. So transparency obligations are imposed on high-risk AI, whereas non-high-risk AI are subject to voluntary codes of conduct. And here you can see the essential obligations on this slide. So developers of high-risk AI are instructed to design and develop systems in a way that ensures their operations are sufficiently transparent, and they provide information for use that include clear, concise, complete, correct information that is comprehensible to users. So it is not extremely clear what information would afford sufficient transparency in this sense, which adds a little bit more confusion to the GDPR regime. But this only concerns the high-risk AI, like I said. The Title 4 here, like I said, is the transparency obligations that are applicable to the limited risk group. And here we see 2 user and 1 provider obligation. And the provider obligation here is the bot disclosure, which is disclosing that the user is interacting with an AI system. The second is an obligation put on the user, and that is informing the exposed persons of the use of emotional recognition tools and the biometric categorization process, which would already be covered in the GDPR. And lastly, we come to the deepfake disclosure. And here the definition of user excludes personal activities. So it would be fair to assume that this is going to affect a very small portion of deepfakes that are currently in circulation. So in general, it is fair to say that there is a stark divide between high risk versus limited risk AI in terms of transparency, and these transparency obligations add quite little to the already existing GDPR regime. So my last remarks. Opacity in AI and machine learning is a complex issue, and it depends on the particular stakeholders, their interest and sophistication. And this opacity, generally speaking, can be caused by legitimate business interest, tech illiteracy, lack of competency of the courts, and the opaque characteristics of the AI model. So explainable AI is a very valuable field to enhance explanations of transparency and trust, but transparency and trustworthy AI are bigger issues that need addressing in many different fronts. We need to raise the transparency and trust both in the socio-technical decision-making the AI is a part of and the sector produces it. We need to advocate for raising the competency of enforcers to protect the safeguards and rights of affected individuals. And lastly, different explanation models are being discussed for different types of AI to allow affected individuals to use their rights. And this concern could also affect the AI model chosen for the job. So this is all I want to say. These are my sources. And thank you for listening. I'm looking forward to the discussions.